California pays for this work. California does not require the work to be performed in California. The money is appropriated here. The work is done 11 time zones away. None of this is against the law. I'm Dave Woolley. Welcome to Buy California. Every dollar of California taxpayer money that funds public works projects is presented as supporting California jobs, California wages, and the California economy. But there is a mechanism in many of these public service contracts that allows that taxpayer money to be legally routed offshore. Legally, quietly, and with zero disclosure to the underwriting public agency. Today, I'm going to show you exactly how that works using a real contract, pre-qualified architectural engineering services contract between the City of LA and AECOM, dated July 8th, 2025. Contract number C-202131. We're going to follow the money through the actual document. Before we get into the contract itself, let me provide context that might be missing. There's been a lot of conversation in this country about offshoring, manufacturing, tariffs, reshoring, supply chains. What is not being discussed at the same scale or larger is the offshoring of professional services. Tens of thousands of engineering jobs that include CAD, BIM, GIS are being offshored to the Philippines, India, Mexico City. These are not just small operators. These are large American companies that have significant contracts building American infrastructure. If you're a licensed land surveyor or a professional engineer, you know what I'm about to describe. You've lived it. In addition to education, most states require 2, 4, or 6 years of qualifying experience under the direct supervision of a licensed professional before they're allowed to sit for the exam. These requirements exist because the law recognizes something that is important. A license is not issued based on an academic credential. It is evidenced by supervised practice, competency, real-world field experience, real liability, and consequences. The California Business and Professions Code doesn't concern itself with the grades you may have received in a certain class. What they're concerned about is, can you perform the work competently? California's definition of responsible charge doesn't require the technical term of direct supervision. You can supervise work and be in responsible charge of work 2 counties away, 2 states away, or 11 time zones away. What that means is the engineer in training that may have graduated from Cal State Long Beach or Cal Poly Pomona that needs 2 to 4 years of supervised experience is not getting that experience because that work is being rerouted to India. To be absolutely clear, this does not mean that every engineering decision being made is made overseas. The issue is the production level work that is required to get the experience required to become a professional engineer is being distributed globally while remaining under the responsible charge of California professionals. I'm sure it's the same in every state. The path to licensure just doesn't slow down, it stops. Engineering licensure is built on an apprenticeship. BIM coordination, CAD level production, utility extraction is typically how junior professionals achieved the supervised experience required to become a professional engineer. The engineer in training isn't simply competing with somebody that sits in India. They're competing for entry-level jobs that require BIM work, CAD production work, drawing street improvement plans from standard plans. This is how most young professionals get the qualifying experience to sit for an exam to become a professional engineer. Take your typical engineering graduate from Cal State Long Beach, Cal Poly Pomona, UC Irvine. That person typically needs to earn about $60,000 a year minimum. That's $30 an hour. The fully burdened cost to the employer after you factor in sick leave, vacation, health insurance is going to be about $90,000 annually. In India, that same position costs about $9,500 to $23,000. In the Philippines, $7,500 to $16,000 annually. The delta between what a firm would pay somebody in India or the Philippines compared to a recent graduate from Cal Poly Pomona, UC Irvine, Long Beach State is anywhere from $56,000 to $146,000 per year per employee. At scale, With thousands of employees working offshore, this results in hundreds of millions of dollars of structural profit that local firms will not realize or cannot compete with locally. WSP established its Global Capability Center in 2009. That operation has grown to approximately 6,000 positions spread out over 5 countries: India, Colombia, Mexico, the Philippines, and Romania, supporting projects over 26 nations. WSP does not obscure this. It's in their annual report. It's on their global leadership page. Understand that these are not isolated examples. Let me show you exactly how it works in a public service contract. Under current law, this structure is quite likely permissible. The question is whether or not these public agencies and taxpayers understand how these contracts function in practice. What you're looking at is a City of Los Angeles contract C-202131, a 5-year pre-qualified on-call architectural and professional services contract, executed on July 8, 2025. 83 firms responded to the request for qualifications. AECOM was awarded the contract. The contract was awarded through the city's Bureau of Engineering. Look at Exhibit H. This is where the financial structure becomes visible. The contract establishes billing salary rates, a BSR, a base salary rate assigned to every classification. The overhead cost is set at 180% of the base salary rate. The profit is set at 10% of the base salary rate and the overhead rate. A 3.08 multiplier is rather standard for California professional services. The cheapest classification is an architectural intern with a base salary rate of $30 an hour, roughly $60,000 a year. Overhead at 180% is another $54. Profit is $8.40. The total billed to the city for 1 hour of work is $92.40 an hour. The 3.08 multiplier, as demonstrated in this example, is standard. Now look at the architectural BIM specialist. Base salary, $120 an hour. Overhead, $216. Profit, $33.60. Total billed to the city is $369.60 an hour. Keep that number in mind. BIM specialist in India earns less than $10 per hour. Now, fully burdened under the same structure, this would be $30 per hour. The framework of the contract values this position at $369.60 per hour, according to Exhibit H. That is a $339 gap per employee per hour. Or when I say gap, I mean arbitrage. Okay, let's set this contract down for a moment. Let's put aside the public tax dollars. The model you just watched, pay one rate, bill another, keep the difference, remove the document that would show it, is not a theory. As of June, it is in federal court. Ford has sued a Los Angeles law firm, not about cars, about labor and where it was performed. Ford alleges that the firm ran its cases with overseas workers in Mexico and the Philippines. It paid as little as $13 an hour. The allegation is that armies of non-lawyers located overseas, places such as Mexico and the Philippines, and paid as little as $13 an hour and billed the same work to Ford as California attorney time at $350 to $950 an hour. One entry shows the chain. An initial client call billed as a partner at up to $550 an hour. Handled, Ford alleges, by the overseas worker that the firm sometimes calls a bot. $13 in, $500 out. The same task. The firm denies all of it and calls the claim absurd. No court has found it liable of anything. Here is why it matters. Ford could see the bills. Even so, it took years for them to file a lawsuit to surface this. The City of Los Angeles, under the lump sum provisions of the contract, holds no bills at all. The lump sum removed them. The subsidiary exemption removed the name. Ford could at least see what they were paying for. The city cannot. Now, back to the contract. Here's where the rate schedule becomes irrelevant. Article 10 of this contract allows the city engineer, at their sole discretion, to choose the form of compensation for any given task order. One of those methods is lump sum. Article 10.3, Article 2 defines it as an all-exclusive payment based on delivery milestones or a stipulated scope of work. All of the consultant's costs, including direct salaries, profit, overhead, sub-consultants, are wrapped into this lump sum contract. Article 10.7.2 describes what these invoices will look like. Upon completion of each milestone, the consultant submits the documentation and the invoice associated with that milestone. Under the time and materials cost reimbursement model, there is a direct connection between the person doing the work, the billable rate, and the hours billed to the project. The contract under the fixed fee structure does not require them to disclose the location of the work, the person who did the work, or the labor cost associated with that work. Here's how it works. The city will have a scope of work, and under an on-call contract, they'll issue that scope of work to AECOM to generate a proposal. The project manager will generate a cost estimate based on the contract rates shown in Exhibit H, the California rate schedule. The city will evaluate the proposal, applying the rates shown in the Exhibit H, $369.60 an hour for a BIM specialist. Typically, they will negotiate the scope of work and the final cost proposal. Now, prior to issuing a purchase order, they may decide to turn this contract into a lump sum tied to milestones. Understand that there is a distinct advantage to the project manager working for the city to use a lump sum contract. This will relieve the project manager of auditing complex invoices tied to individual man-hours. It is much easier to audit milestones tied to very specific dollar amounts than it is to track man-hours and percentages of completion. Basically, it makes the job a lot easier, and there's very little opportunity for that project manager to realize failure. That is the incentive for lump sum on the city side. Now, on the consultant side, the incentive is the delta between the cost of labor in California and the cost of labor in India. The proposal framework is built on the California rate assumptions. If the work is later performed using offshore labor, that gap between the California rates and the offshore labor, $330 an hour, remains with the firm. As Charlie Munger once said, "Show me the incentive and I will show you the outcome." The city project manager has an incentive to use a lump sum contract. The consultant has an incentive to send this work offshore to India. The attorneys reviewing the contract have no incentive to question the geographic location of the labor because nobody is asking. Every actor in this system is doing exactly what the incentive structure tells them to do. And to the STEM graduates, the ones that we told, go get a degree in engineering, get a job at one of these big firms, well, they're seeing the employment pipeline collapse. And this is not because there's no work. Certainly the work is there, but it's being performed 11 time zones away. When $1 of engineering wages is paid to a California engineer, the financial benefit doesn't just stop there. That money pays rent, mortgages, buys groceries. It will fund a school district through local taxes. It supports the businesses that support employed households. These economic effects are real and they're measurable. When that same dollar is paid to an engineer in India, those same local effects are not felt in California. The tax base receives nothing. The school district receives nothing. The businesses that rely on the income of local paid professionals receives nothing. The work leaves and the dollar leaves with it. And the local economy gets no return on the publicly funded contract. AECOM's Form 10Q, filed with the Securities and Exchange Commission in August of 2024, discloses that approximately $1.3 billion, in their own words, intend to be reinvested in those economies indefinitely. That figure is in the filing. It is not an allegation, it is a disclosure. In their most recent annual report, AECOM discloses that the number is too complex to be calculated. The precise figure, in their own words, is not practicable to state. Some of the work that those clients generated for those Indian engineers comes from American taxpayers' public works projects. That money stays offshore by design. Most engineering contracts require the prime consultant to disclose any subconsultants, and in doing so, the city, in this instance, has the right to accept or reject each individual subconsultant. This is standard. Article 9 of this particular contract contains this provision. AECOM must provide the city a list of all subconsultants, including the name and address. The city has the right to approve them. The city has the right to reject them. And then this sentence. Wholly owned subsidiaries of the consultant shall not be considered subconsultants. AECOM India Private Limited, registered with India's Ministry of Corporate Affairs as a subsidiary of a company incorporated outside of India, operating under the AECOM brand, using AECOM email addresses, performing architectural and engineering work, is not a subconsultant under this contract. It does not have to be named. It does not have to be disclosed. The city does not have the right to accept or reject it. The City of Los Angeles, through contract language of their own drafting, does not appear to create a direct mechanism that requires the disclosure of the geographic location of the labor for wholly owned subsidiaries, or whether the work completed under this contract was completed by folks in California or even the United States. This ownership change was documented by 3 separate sources. AECOM's own website says AECOM Technical Services is a wholly owned subsidiary of AECOM. India's Ministry of Corporate Affairs registry classifies AECOM India as a subsidiary of a company incorporated outside of India. And in January of 2024, the Indian government formally disciplined AECOM India for failure to meet public obligations, confirming that the entity is active under the Indian jurisdiction and operating at scale. 3 sources, no inference required. The subsidiary exemption under Article 9 is the lock on the door. The lump sum provision removes the audit trail. Together, they reduce the visibility of the labor geography within the structure of the contract itself. This contract is not unusual. It's not an outlier. It's standard for the industry. Let me show you what this contract does regulate. The contrast is actually the argument. This contract requires compliance with the Living Wage Ordinance, the First Source Hiring Ordinance. It requires MBE, WBE, SBE, EBE, and DVBE participation at specific percentages. 18% minority business, 4% women-owned business, 25% small businesses, 8% emerging businesses, 3% disabled veterans. It requires compliance with the American with Disabilities Act, the Slavery Disclosure Ordinance, campaign contribution restrictions, child support assignment obligations, and data protection requirements. It does not contain a single provision of disclosure of the geographic location of the work being performed. This is not a document oversight. This is standard. This is what a contract looks like when it's silent on the geographic location of the labor. The billing structure creates the incentive. The lump sum provisions remove the visibility. The subsidiary exemption removes the disclosure. The absence of a geographic labor clause removes the constraint. Together, they produce the outcome I've been describing. This is not an accident. This is institutional architecture. Unlike the construction trades, oftentimes subject to project labor agreements that require a physical presence on site, the geography is inherent to the work. Professional services do not have this same constraint. They're neither subject to project labor agreements or geographic location. The structural calculations, the engineering design work, the BIM work, the GIS work, the CAD work can be performed anywhere. The only mechanism to change this is contractual language. The contracting authority doesn't need new legislation. They don't need to rely on a regulating agency to modify the language in these contracts. It simply needs to make a decision. As an example, the following clause would change everything. All work performed under this contract shall be performed by personnel physically located within the state of California unless prior written approval is obtained by the city engineer. That language is grounded in the market participation doctrine and is reinforced through the Little Brooks Act, Government Code 4525. And where there's federal funding involved, there has to be additional language to support the Commerce Clause. But that does not mean this work has to leave the United States. That means that hiring California labor is a preference, however, it may not be a restriction. This is simply a question of drafting the language, not a policy barrier. I want to show you what this market looks like at the ground level. Like many engineers and land surveyors, I receive solicitations 2 or 3 times a month for services to be offshored to India. These will come through cold calls or through LinkedIn. As I mentioned earlier, these firms are offering BIM services, GIS, CAD mapping, drone processing, LiDAR scan data processing. Now, the call you're about to see was recorded with full permission. In fact, they recorded it and gave it to me. I'm going to obscure the faces and identities of these folks because who they are is unimportant. What is important is the message.
Okay. And then do you just, everything's fixed fee? There's no hourly rate or anything like that?
Yeah, so this is hourly rate. So our price starts from $10 per hour and it goes up to $15 per hour. It depends on how complex the project is.
Okay. So
Yeah.
basically it's costing $10 to $15 per hour.
Yes.
That's really reasonable. You know, that's not even
Yes.
like minimum wage
That is
here.
the only benefit having a production team over in India. So this part of the world is very cost effective.
So $10 to $15 per hour. So even on overtime, even if it was $25 an hour, you know, that's considerably less than what they would charge here.
Yes. So that's the reason the industry is growing, and day by day everyone is moving towards offshoring.
As you may have picked up in that phone call, they're going to charge me as a service provider $10 an hour and no more than $15 an hour. This is a third-party vendor offering services in the open market. Both models exist, and both are soliciting American engineering projects. These calls go to firms of every size. This would include a 50,000 person infrastructure engineering company or a 3-man outfit working out of a garage. It is my understanding that there are several small drone operating firms that offshore all of the mapping to India. These are sole proprietor land surveying firms. No project is too large, no project is too small. Many of these services require professional supervision. The geographic labor question that we've been examining is built into the contracts. But what I'm seeing now, there is a second mechanism in place now that is accelerating the entire process. In November of 2025, AECOM purchased a Norwegian company for $390 million called Consigli. Consigli markets itself as an autonomous engineer. In its own materials, it says that up to 80% of the engineering can be automated. AECOM has publicly stated that their margin goals, profit, for 2028 is 20%. They're telling their investors what the incentive is. The outcome for the young American engineering graduate is the same, regardless of which mechanism. That is the next video. Following the Palisades fire, the most destructive urban fire in California history, AECOM was awarded the contract C-202131 to help rebuild. AECOM is a qualified firm. They certainly have the capacity. Those are not the questions. As of the recording of this video, the contract is less than 1 year old. We have no indication one way or the other that any work awarded under this contract has been offshored. That is not a hedge. That is an accurate statement as to what is knowable at this point. The City of Los Angeles does not know either. The contract does not require disclosure. The subsidiary exemption under Article 9 that we reviewed earlier applies to this contract and any contract with similar language. The people of Palisades who lost their home need an income. Many of them are the same professional, engineers, architects, geologists, that are seeing that work contracted and routed offshore. The school districts certainly need the revenue. The fire departments need the funding through the tax base. Every disaster recovery dollar that is spent offshore does not recirculate in those communities. The local economic effects no longer remain in California. In some cases, those dollars are funding offices in other countries. In March of 2025, the state of California ordered its own engineers back to their offices, 4 days a week. The order is set to take effect July 1st, 2026. The engineers union fought it. A bill followed, Assembly Bill 1729, to require every agency to justify in writing why the work has to be done inside of a state building. For more than a year, the state of California has argued in an executive order, at the bargaining table, on the floor of the legislature, and in the street over whether its own engineer works from an office in Sacramento or from a home about 20 miles east in Folsom. The state knows how to care where the work is performed. It cared enough to spend a year on 20 miles. The contract you just read pays for engineering performed in another continent. It requires no justification. It requires no disclosure. It does not ask the question at all. Same state, same kind of public dollar. For an engineer that it employs, the location of the work is worth a year of fighting. For the engineer it pays for, the location of the work is not worth a single line on a page, which is the question this entire episode has been building towards. David Woolley for Buy California.